Once again, good afternoon. This is Tony Gabart of End Domestic Abuse Wisconsin. Thanks for joining us today to learn about legal advocacy updates and recent and upcoming restraining order change.
Sounds great, Tony. Can everyone hear me? Or, Tony, can you hear me?
I can hear you and everyone else is muted, but if there are any problems, folks can always type in the chat and we can try to get that addressed.
Okay. Well, let's get started. Thank you, Tony, for the introduction. We are going to cover current and pending restraining order changes as well as several other items that have or will change. So we're going to be talking about 2015 Wisconsin Act 253, which went into effect and allows the court to order respondents to not engage in household pet abuse, as well as 2015 Wisconsin Act 349, which asks and now requires the Clerk of Courts to forward information about restraining orders to the sheriff. 2015 Wisconsin Act 253 becomes the law on July 1st. It allows the court to transfer certain wireless phone numbers. We're also going to talk about an act that has been in effect for a while, 2015 Wisconsin Act 4, because I hear occasionally about confusion about personal jurisdiction across interstate abuse cases. Then we'll spend a few minutes on 2015 Wisconsin Act 351, which goes into effect August 1st, and that is a victim accompaniment law in the criminal justice system. 2015 Wisconsin Act 356 is an address confidentiality program, and then we'll end by talking about court filing. So let's get started. The restraining order changes affect all types of restraining orders: the domestic abuse, harassment, individuals at risk, and child abuse. 2015 Act 253 went into effect on March 3rd. And all of our restraining order petitions and other forms have already been modified to show that change. The change is that you now can, as a petitioner, check a box that says you ask the court to order the respondent to refrain from removing, hiding, damaging, harming, mistreating, or disposing of a household pet. You can also ask the court to allow the petitioner or a family member, household member on behalf of the petitioner to retrieve a household pet. In addition, one thing that is perhaps important to know, I think this is going to come up from time to time, and that is what is the definition of a household pet. It means a domestic animal, not a farm animal, and that the pet, domestic animal, is kept, owned, or cared for by the petitioner or a family member or household member of the petitioner. This bill was designed to allow for the kind of extended animal abuse, pet abuse that some respondents and abusers engage in, not necessarily harming the petitioner's animal, but a child's animal or someone else who is close to the petitioner or within that household. As a result of those changes, all of the petition forms changed in 2016. You can request the household pet abuse provisions in either or both the TRO or injunction. We do not know how pet retrieval will occur. I suggest to advocates that you may wish to talk to your petitioners when they are at the injunction hearing to set up a schedule, an arrangement between the respondent and law enforcement at that injunction hearing so that you don't have to go back to court to make that happen. Let's move on to Wisconsin Act 349. It says that clerks of courts, as of June 1, are now required to forward to the sheriff any TRO, injunction, or other documents, notices that have to be served by the sheriff. And this was intentionally passed to allow petitioners to not have to take their orders to the sheriff's department. Basically, it was passed because there are some counties in which a petitioner has to go a long way from the courthouse to the sheriff's department in order to make service happen. And many of those cases, it has been discovered the petitioner receives the TRO, the date of the injunction, but never gets to the sheriff's department to ask for the service. The advocates report in those counties that it's because that person didn't have time to do that next step. So Act 349 is designed to take care of that. If there is an actual service fee, and there generally is not a service fee, but should there be a service fee, and that would only be in a harassment case under select circumstances, the petitioner will have to pay. So a review of when a petitioner will have to pay in a harassment case, if the petitioner alleges stalking or any other type of behavior which fits under the domestic abuse restraining order, they do not have to pay. In all other circumstances, if the petition does not allege stalking or another domestic abuse behavior, they will have to pay. And in that singular circumstance, the petitioner is going to have to pay for the service and will have to pay the sheriff directly. These are the instructions that were sent by the Supreme Court's Court Operations Office to Clerks of Courts. For those of you who have asked, and many folks have been inquiring, what are the Clerks of Courts being told? What do they know about this bill? Hopefully by now, because it's almost 3 weeks old, they have read and they're working on this change in the law. The statutes do not tell us how the clerks are to forward the TRO, injunction, or other documents. So this will require that the clerk of court work very directly with the sheriff's department to figure out what they're going to do about service, and primarily about service outside of the county. The two options that are included in the memo that was sent to Clerks of Courts, the clerk can send the order to the sheriff of the county where the case was filed, and that sheriff will work with the other county. The clerk will send the order to the county of the sheriff where the respondent resides, and that sheriff will serve the document. And it is suggested to the clerks that they make sure they have a fax number and determine whether that county uses a respondent information form. If your county is using some kind of an information form, whether that's about the respondent or another party, be sure you discuss with your clerk of courts how that information is now provided to the sheriffs. For out-of-state service, which could raise many of the same issues as out-of-county service, the statutes, again, do not provide the guidance, and the memo to the clerk says, talk to your sheriff's department about how you want to handle that. Here are a few options. You, the clerk, could send the order to the sheriff where the case was filed. That sheriff will assist. Or, and this is where you as domestic violence advocacy agencies come in, if your process in your county is already involving you helping with assisting the petitioner with service, it is likely that that is continuing to be the process now. Again, this is 3 weeks old, so you may well have this in place. Either the clerk or the sheriff can inform the petitioner of the option to hire a private process server. However, petitioners should not be told that they must hire a private process server because that violates federal law. And you can see the federal law there on the screen, and the site for the federal law The cite comes from 42 United States Code, and it says that states that receive VAWA funds, Wisconsin does receive VAWA funds, are subject to a federal law that prohibits victims from bearing any cost associated with the service of a protection order. So in summary, if your county is using a respondent information form, you would want to have your petitioner complete that form and give it to the clerk once the petitioner is notified that he or she is subject to the TRO and the injunction hearing is going to be scheduled. The clerk will then send that to the sheriff's office. The clerk will keep that form confidential because it may contain confidential information. The clerk and the sheriff will have to work out exactly how these policies are going to be operating, whether it's by fax or hand delivery. The State Court Operations Office has asked the clerks to not use email as a method for service of restraining orders for two reasons. One, there is some prohibition in our statutes and policies that say that it is not to be used. And second, e-filing is coming down the line, will be happening in the future, and this is an effort to make sure that clerks do not become accustomed to using email when in a short number of years that would not exist anymore. We think that issues that could come up with this new law, Act 349, and the clerk helping with service, it's unclear how the counties are going to collaborate and how well they were collaborating. We think that the role that the advocate played in the past is likely to remain the same, but again, we don't know. So as an advocate, you may wish to have your agency make a contact with Clerks of Courts. In addition, this law actually went into effect on June 1, but there will be no changes in the injunction forms until July 1. The reason that the Records Management Committee determined to wait until July 1 is there are other changes to restraining orders as of July 1. So rather than have all new forms in March, all new forms in June, and another new set of forms in July, the forms have not changed to reflect that the clerk will now help with service. However, all the clerks have received the memo from which I just read. I also want to point out that if you are experiencing difficulty with the cost of service, please look at our restraining order grid where we offer a number of different suggestions for who you might want to contact. Let's move on to the other law that impacts restraining orders, takes effect on July 1, and is the reason that we are waiting, that the Supreme Court is waiting until July 1 to issue all new restraining order forms, because this law does refer to and impact all four of our restraining orders. It says that a petitioner can request the judge or court commissioner, the person who issues the injunction, to order a wireless telephone service provider to transfer a telephone number or numbers that are being used by the petitioner and or by the petitioner's minor children, that the court would transfer the exclusive use of that number to the petitioner. Again, it applies to all four types of orders and takes effect on July 1. So if you look at the forms right now, you're not going to find this provision. You will find it as of July 1. What's going to happen, as I mentioned, is a new form will, all of our forms will change as of July 1 and include on both the TRO petition and the injunction forms that the ability to ask for this wireless service transfer is a remedy that the petitioner can request. In addition, there will be yet another new form. This is entitled CV, which stands for Civil 437. It is entitled Wireless telephone service transfer order in an injunction case. That form states to the phone company that the court has ordered the ability of the petitioner to have that number exclusively transferred to him or her, the petitioner. The form only contains the names of major phone companies, and here at INDABUSE, Tony is working on getting the information as to where the petitioner sends or takes that form. The 5 different providers, phone providers, who will be included on the form and information about where to send the CV-437 are AT&T, US Cellular, Verizon, Sprint, and Cellcom. That does not mean that a petitioner cannot ask for wireless transfer of all the other many, many different phone companies. It means that information about how to reach them, to where to send that form, CV-437, is not going to be available on this form, on CV-437. Tony and others have engaged in conversations with those who wanted this law passed, and they consider those the 5 major carriers. So a petitioner will need to find out to what place to send CV-437 in order to have that phone company engage in the process of having the number changed. It is also the case that the petitioner is responsible for any financial cost involved with that transfer. I'm going to quickly review Act 4, which went into effect in April of 2015. It expanded the right in Wisconsin for courts to issue either TROs or injunctions in interstate abuse situations. I know that we've covered this in the past, but I continue to hear from both advocates and members of the judiciary that they may not be very familiar with this law. So I wanted to take this opportunity to remind advocates that there was a change in the law. It went into effect in April of 2015. That act clarifies that Wisconsin courts have subject matter jurisdiction in restraining order cases that involve abuse and harassment, regardless of where that abuse or harassment occurred. Now, the slide notes that that's civil abuse. What we mean by that is the types of abuse that are listed in a civil restraining order under Chapter 813. The court, however, has to have both the subject matter jurisdiction, the authority to hear the case. It also has to have personal matter jurisdiction, authority over the person, the respondent, in order to hear a restraining order case. In the past, it was difficult for courts to issue restraining orders, or they didn't know if they had the authority, personal jurisdiction, over a respondent who is in another state. If you look on any of our restraining order forms, you will find a statement that the court may not issue a restraining order unless it has both subject matter and personal matter jurisdiction. As I mentioned, Act 4 confirms that the courts have the subject matter jurisdiction, and primarily Act 4 was intended to address what were previous limitations about personal jurisdiction. Prior to Act 4, Wisconsin did not have clear personal jurisdiction in cases in which the interstate harassment and stalking, again, by virtue of saying interstate, occurred across state lines, or in situations in which a victim flees to Wisconsin but the abuse was committed in another state. So Act 4 expanded Wisconsin's definition to say that communication includes communication through the mail, telephone, electronic message or transmittal, posting on an electronic communication site or web page or other electronic medium. The Act 4 also goes on to say that there are 3 ways in which the court can take personal jurisdiction or does have personal jurisdiction over the respondent. The first basis is called adverse effect. The second is when a party is seeking safety in Wisconsin, flees to Wisconsin. And the third basis, which has been there all along, is that the personal jurisdiction is allowed under the Constitution. The first basis, adverse effect, says that if the petitioner or a member of the petitioner's family or household, if that person can show that there is an ongoing pattern of harassment, that the petitioner now resides in Wisconsin, and the respondent is having direct or indirect communication with the petitioner or a member of the petitioner's family or household, that the respondent has indicated that he or she is indicating a threat to the physical health, safety of the petitioner, member of the petitioner's family or household, and the petitioner and or family member and household member is temporarily residing or lives in Wisconsin, but the respondent lives elsewhere. Those are the circumstances in which the court has personal jurisdiction over the respondent due to the adverse effect. The second situation deals with seeking safety or protection in Wisconsin. If the respondent has or had direct, indirect communication with the petitioner or a member of the household or family, the respondent indicates a threat to the physical health and safety of the petitioner, member of family, or household, and the petitioner or member of the family are residing in Wisconsin and or temporarily living in Wisconsin, again, the respondent is elsewhere and is engaging in threats, again, that can be a basis for the court to take personal jurisdiction. This was designed for circumstances in which the harassment is occurring, and as a result, the petitioner, let's say that the petitioner and respondent were elsewhere, the threats were being made while in another state, the petitioner flees to Wisconsin. This is the circumstance that that's intended to address. And then, as we noted, you can, and the courts always could and had permission under the United States or state constitution to allow the widest possible reach. It's possible that if you're uncertain, the petitioner is uncertain as to whether the court has personal jurisdiction, the petitioner can ask the court to explore that under the Constitution. Okay, those are the restraining order changes, and all but the wireless service have already gone into effect. I also want to quickly talk about, because I want to allow time for questions, 2 other laws that do not have to do with restraining orders but do impact victims of domestic abuse and or sexual assault. One is called the Victim Accompaniment Bill. It goes into effect on August 1st, and if you look at it in the statute, it's entitled a victim advocate. These next slides are taken right from WCASA's website in their policy and law section, so I gave you links so that you can look up more information if you wish to. The Victim Accompaniment Bill says that with a few exceptions, the law allows survivors of sexual assault, human trafficking, child sexual abuse the right to be accompanied if they choose to do so. This law empowers the victim to make this choice. However, it does not give an advocate the right unless the victim so chooses. And it says that that would be a sexual assault victim advocate, and this only applies to the criminal justice process. So unlike, and some folks have asked me, well, how is this the same or different, or is this just more of our victim service representative law? No, victim service representative laws apply in primarily in our civil cases in restraining orders under Chapter 813 or family law proceedings. The new law that goes into effect in August is strictly within the criminal justice process. It defines a victim advocate as an individual who's an employee of, volunteer for an organization whose purpose is to provide counseling, assistance, or support services at no cost. And again, the victim is the person who has experienced sexual assault, human trafficking, and or child sexual abuse. If you notice that victim advocate definition, that comes from and is similar to the definition for victim service representative law. The law allows accompaniment by an advocate with a victim in several places. One is the hospital, and it says that a hospital that provides emergency services, if the victim requests, may permit a victim to accompany that victim to an exam or consultation. However, it also notes that hospitals don't have to wait for that advocate before they begin the exam or begin treating if delay endangers the health or safety of the victim or the potential of losing evidence. This law also addresses minors. We know that the law was designed to assist adult victims, but it also says that a minor who's a victim of sexual assault, human trafficking, child sexual abuse can make the request for the victim advocate without the consent of his or her parent, guardian, or legal custodian if you are 10 years of age or older. If you're under 10 years of age, the medical provider can make that request. The hospital is required to notify the victim and the victim's parent, guardian, or legal custodian if the minor has requested that a victim be with him or her, and if the hospital has is required to permit a different victim advocate if the victim does not want that particular the advocate who shows up, the victim for whatever reason says, no, I want a different advocate, the hospital has to notify someone of that decision. An advocate can be excluded if their presence obstructs the provision of necessary medical care or they fail to comply with hospital policies. And some of those hospital policies are noted here, confidentiality, or the request by a victim. If a victim says, I don't care for, and I'm not willing to have this advocate present, they don't have to state what their reasons are. The hospital can then ask for a different advocate, or perhaps there will not be an advocate. The other places in which a victim has the right to accompaniment by an advocate in the criminal justice system includes law enforcement interviews and other proceedings. Again, with some exceptions, the victim advocate can be present at interviews and proceedings in which the victim is requested or allowed to attend because that proceeding is related to the crime. That could include prosecution interviews, Department of Corrections proceedings, court proceedings, post-conviction proceedings. A parent, guardian, legal custodian who is a minor may request that the victim advocate accompany the victim at those law enforcement interviews, as well as interviews and proceedings. Advocates can be excluded if they break the rules. And of course, the major rule is obstructing the ability of the law officer for that law officer to ask questions or interrupting or trying to explain or speak on behalf of the victim. The other place in which the victim accompaniment bill applies or will apply as of August is child forensic interviews. Once again, the law notes where you can be excluded, and it says that you can be excluded if the victim what it says is a victim advocate may not obstruct or delay the forensic interview, shall comply with instructions or requests from the lead forensic interview, including that the forensic interviewer may ask that person to exclude him or herself during some portion of that child forensic interview, and shall comply with rules and policies. The victim advocate accompaniment law is not retroactive. What that means is it takes effect on August 1. The violation then has to be committed against the victim on or after August 1. The accompaniment law also made some changes in our existing laws to change wording from advocate to victim advocate, because as I noted earlier, the statutory definition for this criminal accompaniment law is entitled victim advocate. So when the law applies in certain select other laws, it specifies victim advocate as opposed to the word advocate, which you will find in other places in the statute. The victim accompaniment bill, while we at End Abuse fully supported it, it was under the efforts of WCASA, Wisconsin Coalition Against Sexual Assault. So I have given you the names of the two persons who you could contact with more information, and I also gave you links to the website that has a lot more detail. Let's move on to the Victim Address Confidentiality Program. This does not go into effect until 2017. It has now been, the Department of Justice has now entitled it the Address Confidentiality Program, ACP. It's 2015 Wisconsin Act 356. It creates the confidentiality program. It's administered by the Department of Justice. It's designed for victims of child abuse, domestic abuse, sexual abuse, stalking, human trafficking. Under this act, if a person is eligible to participate if a Wisconsin resident and either is a victim of abuse, the parent or guardian of a person who's the victim of the abuse, a resident of the household in which a victim of abuse resides, or the person is eligible to participate if they fear that his or her physical safety or the physical safety of his or her child or ward is jeopardized. Address Confidentiality Program provides that those who are eligible will be given an assigned substituted address. Mail is sent to that substituted address and is received by the Wisconsin Department of Justice and then forwarded to the actual address at which the ACP participant lives. The Wisconsin Department of Justice is in the process of setting up eligibility requirements. However, they've begun that process, and there is already quite a bit of information available. The program already says that you can be in one of the specifications that they've already set up is that you can be enrolled in the ACP for up to 5 years. You will be enrolled for up to 5 years, for 5 years, unless you as the participant cancel. The law also states that each ACP participant must develop a safety plan with a DOJ designated program assistant. I think this is going to be important to all of us as advocates, because it goes on to say that those who have the right to help develop the safety plan include employees of DOJ. Now, I'm certain that they are working out which employees and what kind of training they will have. It also includes employees of states, local agencies that already provide the counseling, assistance, support services to victims. I am thinking that that will include victim witness. And then finally, it says an employee or volunteer of or for an organization that provides those services to victims free of charge, which could be any of our advocates in domestic violence, sexual assault programs. A person, as I said, has to satisfy certain requirements. Those are still being worked out. Obviously, one of those requirements is that they were subject to one of these types of abuse. And it also goes on to say that you can be eligible regardless of whether there were actual criminal charges, whether they've been brought against the person, or whether the victim sought a restraining order in relationship to that abuse, or whether the person has reported acts or threats against him or her to a law enforcement officer or agency. So once DOJ assigns the address, DOJ may not disclose their real, actual home address unless they are subject to a court order, or if that address is to be given to a law enforcement officer for an official purpose. In addition, if a participant submits a written request to a local clerk that he or she is to keep the participant's actual address private, the clerk may not reveal that information unless subject to a court order. The Act allows a program participant to use the assigned address for all purposes, that no state or local agency may refuse to use or allow that address unless, again, there's specific statutory duty or some requirement that the participant's actual address be used. I don't know how that will play out. That remains to be seen. No person who receives a notification form from the participant may refuse to use that address, and they may not disclose the actual address or intentionally disclose to someone else that address. However, the municipal clerk may require additional information to provide or verify their actual address for voter registration and verification. Having said that, there will be the opportunity for the program participant to engage in the confidential voter program, in which their name and address are not disclosed. The details of how this will all work out with municipalities is still being worked on. The municipal clerk must require the participant to disclose that actual address in order to enroll them in the confidential voter program. And then, of course, that information is kept confidential. DOJ, as I said, sponsored this bill, and they are the agency responsible for its implementation. It goes into effect April 1 of 2017. So there are a lot of administrative and details about regulations that are still being addressed, formulated, although I do know that DOJ within the last 2 weeks began the process of releasing some of their plans for the administrative regulations. If you, we can expect that there will be more information about this, and I presume that DOJ will be doing trainings on this issue, perhaps through Morgan Young, our former immigration and poverty law attorney, because she is now with DOJ as a training person. But we won't know that until further into 2016 or early into 2017. You can contact the Wisconsin Department of Justice, Office of Crime Victim Services with more questions on how the Victim Address Confidentiality Program will operate if you have more questions. And then finally, I want to mention a Supreme Court rule on e-filing that goes into effect on July 1. What the Supreme Court e-filing rule says is those counties who are already currently using voluntary e-filing, that as of July 1, it will be replaced with what will become established rules for e-filing. So the rule goes into effect on July 1, and the rule is written to say that there will be gradual implementation of e-filing for many different civil cases between the years of 2016 and 2019. This is not going to affect restraining orders for years because there are it's a more sophisticated set of operational needs for e-filing with restraining orders, where the person can file from, how they know it is successfully delivered. There's so many details that right now the court is transferring the cases that have already been done voluntarily, and then they'll begin the bigger process of working on more complicated cases like restraining orders. So mandatory e-filing will be phased in according to a schedule that is to be established by the state courts on a county-by-county or case-type basis. So I am hoping you are all hearing me say that you could be in a county in which e-filing starts July 1, but another advocate with whom you attend a training, their county is not using e-filing, or you may be using it in your county for a type of case but not in another county because it is gradually being phased in. The actual mandatory e-filing will be established first in a small number of pilot counties that are already offering the voluntary e-filing in civil, family, small claims, and paternity cases, and then it will expand within those same case types to other counties by the end of 2017. The targeted date for completion of all mandatory e-filing is December 31st of 2019. Now, having said that, that's a target date. The court is quite aware that they do not know how long it's going to take to go from the current voluntary filing in 52 counties in some or all of these kinds of cases, civil, family, small claims, paternity, how long it will take to get them up and running in a mandatory fashion and then take those same case types to other counties. They hope to do that by the end of 2017 and then branch out to other cases, which down the road would include restraining orders. There will be an electronic filing fee of $20 per party per case, and that will be waived, of course, for indigent parties as well as governmental units such as DAs, public defenders, child support agencies, Department of Justice, county, and municipal attorneys. CCAP is responsible for implementing the Supreme Court e-filing. So that concludes the information that I wanted to cover because I would like to give you time to ask questions. Please know that you are welcome to contact any of us at In Domestic Abuse with questions. I may have to refer you elsewhere if it's about victim accompaniment or about the e-filing or the other new piece of legislation. A reminder that we have an excellent restraining order grid that can also be useful. And at the end, you can see here information about how to reach me. I'd like to open it up for questions.
Thanks, Tess. This is Tony again, and that concludes Tess's portion of the presentation. I will stop the recording, and then we'll begin the question and answer period.